6 days later, he's at the park shooting. The following day, his case was formally dismissed. I mean, the probation was still warm, the end of it, and he hadn't been getting.
Yo, it's your boy Uchi, and today we in Judge John Stevens Jr.'s courtroom, Criminal District Court, Jefferson County, Texas. And I need you to hear me on the front end. This is a bond hearing. Nobody's been convicted of nothing here. The young man is 19. He's got 2 indictments the state says involve deadly conduct, and every bit of that is an allegation a jury ain't never heard. What we watching is one question. Do they let him out while he waits? His people came ready, and I mean ready.
All right, the court has a copy of a public safety report of the defendant. And I'm looking at prior criminal history. They're reflecting, let's see, in history. Showing an arrest date on 3/16/26 for deadly conduct, and it was filed as a misdemeanor Class A. I just don't think that went anywhere. Because I'm looking at the indictment in 26 CR 978, which alleges on or about March 15th.
Yes, sir.
That is alleged he committed deadly conduct, and that's the indictment in 978, which I guess is what guess the misdemeanor must not have been filed, and then the felony was later solved. Then there is nothing about the July 5th deadly conduct here in the July 5th of 20.
Hold up, because this part matters and everybody skips it. The judge is reading the man's actual record out loud, and what he finds is a misdemeanor, evading arrest, 6 months of deferred probation, and it expired. Then he says it plain, I don't see a prior felony conviction. So anybody in the comments about to type that this is some career criminal, the judge himself just told you it ain't. Keep that in your pocket because it comes back.
Raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. Go ahead, Martha.
Mr. Perkins, will you state your full name for the record? Perkins.
Yeah, I can't hear you.
You heard Perkins?
She has to take everything down.
Yeah.
Thank you.
Yeah, she got to take it. Okay. Now, for us, my client, the defendant, Dante Perkins, what is your relationship to him, this father? And where do you currently reside?
1230 Birch Street, Columbia, Texas.
Now, if the bond is able to be reduced where y'all can bond him out, is that where he would be residing?
Yes, sir.
Okay. Who else lives at that home?
His mother, his brother, his sister.
Okay. Typically, what is your work schedule like? Just to kind of put that out.
My work schedule, I work night shifts from 4:30 p.m. to 3 a.m.
Okay. Now, even with that, is there normally someone there to supervise or be around the home to know what's going on?
Yes, and mom.
Okay. Now, when it comes to Dante, at the time that since he's been in custody, prior to that, was he employed or working anywhere?
No, sir.
So he had no funds saved up or money saved up for that time? Sir. Does he have any type of property or anything that can be used to put on?
Now watch how a real release plan gets built. Mr. Perkins is up there giving them the address. Who else is in that house? His own work schedule, night shift, 4:30 in the evening till 3 in the morning. That's a man telling the court the truth, even when the truth ain't helping him, cause you already hear the problem. Who's watching the house at 2 a.m.? He said it anyway. Respect that.
You was one now.
They're both to like 50.
Both at 50,000.
Yeah.
So it would be a current financial obligation of $100,000.
Yeah, that would be a time.
Okay. And that's something that you believe you and the family will be able to do.
Yes, sir.
Okay. So I'll pass the other sheet.
Mr. Perkins, did you assist in bonding Dante Perkins out in 2024 when he was charged with the evading?
Yes, ma'am.
Okay. And were you aware that he pled to that evading?
No.
Are you aware that while he
Was like, well, that's a fact.
Yes, sir.
You're not aware that
Which
your,
means-
are you saying you're not aware that your son pleaded guilty to a crime?
Oh, okay. I didn't understand what she was saying. Said play. Yes, he didn't receive probation for that. Yeah.
Are you aware that while he was out on bond on the evading before he pled, that first July 5th, 2025 deadly conduct charge where he was firing a weapon in the neighborhood of Euclid Street?
And here come the state. She ain't loud. She ain't nasty. She just walking him back through 2024. You bonded him out before. You knew he pled. You knew he got probation. She building something and he answering honest every single time. That honesty is about to cost him.
Who was he staying with?
He kind of back and forth from my house to his friend's house.
Did Dante graduate high school?
Yes, he did.
What year did he graduate high school?
So he graduated. 24. Yeah. 24.
How old is he?
That's it. 19.
So how can you or his mom ensure that the community is safe from Dante out in the middle of the day firing weapons into our community?
So, like I said, he'll be on an ankle monitor, and if Dante does anything outside the guidelines of his bond, I'll get off the bond. So,
Did you know that Dante possessed possessed guns in the first place?
no, I didn't know that he had anything else.
So you feel that an ankle monitor is going to keep Dante from firing guns into our community more than these 2 times he's already done accused of it?
Yes, situation, I'm pretty sure Dante turned around his lesson. With the ankle monitor, he can't no problem with that. So, yes, I do think it would be helpful to.
But the ankle monitor tells the monitoring company where he is. It doesn't stop him from moving around,
It
correct?
doesn't. They don't have a warrant to where he can only be at the house and only go like for a job search or something like that.
So are you aware that somebody can tell him that those are the parameters, but Dante can still go and come where he chooses to?
No.
Are you aware of that?
Well, he's learning about something.
No further questions, Judge?
Just a quick redirect. Mr. Perkins.
19. That's the whole age. And listen to the plan. The ankle monitor is the centerpiece. That's the thing they hang in the whole ask on. Then the prosecutor asks the one question that takes it apart. That monitor tells the company where he is. It don't stop him from going. And Mr. Perkins, to his credit, don't fight it. He says it doesn't. That's 25 minutes of plan coming undone in about 9 seconds. And it happened because the man refused to lie.
It's going to be a good deterrent for him to help him follow his way.
Yes, I think that would be a great turn.
Okay. And just to reiterate, as you as the co-signer on the bond, you have no problem if he doesn't comply getting off the bond, or
No problem at all.
understand that the court would have to do what they have to do
Exactly.
at that moment.
Yes, sir.
Okay. Pass the witness.
You don't think the probation back in 2024 should have been a deterrent?
Yeah, I feel like it should have been,
That didn't work though, did it?
it was just It should have been a deterrent, but at the same time, I think he's been sitting in there for 5 months now, and I think he really sees the seriousness of his actions at this current moment. You know, that was just to me, I just think it was, but him sitting in there 5 months, I think he really sees the severity of it.
No further questions, Judge.
You don't think the probation should have been a deterrent? Man, that question ain't really for the witness. That's the state planting a flag for the judge, and you gonna see him walk straight to it.
Well, we're by grace of the good Lord, I think, we didn't have a bunch of deaths here. What bothers this court is the defendant had been held accountable earlier for an offense and was placed on a form of supervision. And on this evading arrest back in 24, which was a little less than a year before he starts firing weapons in public. And he was placed on probation for 6 months, and that expired. It doesn't say the date it expired, but I presume it expired before the July 5th, 2025 incident. They were on 6 months, but the arrest date was.
Two things in there. One, the judge says out loud, by the grace of God, we didn't have a bunch of deaths here. That's him telling you how serious he thinks this is. Two, he keeps circling the supervision, not the allegations, the supervision. He want to know what that 6 months actually did.
And show the date that he was placed on probation for 6 months. Do you
I
know
believe it was September 10th of 2025, Judge,
that he was placed on probation?
that he was placed on 6 months deferred probation.
So that would have ended in March of
2026,
5.
March of 2026.
Standby. When was he placed on probation?
September 10th of 2025. It should be on or
Oh,
about that day.
okay. It's not showing a date. It says arrest date was 7/26/24. It took him a year before he's placed on probation.
That's what I'm showing in
The date again?
history. September 10th of 2025.
So he would have been placed on probation 2 months after the shooting of the neighborhood.
Yes, sir.
And so he was on.
And now he hunting a date. The file won't give it to him clean, so he keep asking. Watch a whole courtroom go digging through paperwork because now one judge refused to guess. That's the job right there. He could have eyeballed it and moved on. He didn't.
Started when it started midnight on the 14th or 9th. Judge, I show that an order terminating deferred probation was filed in the misdemeanor case on March the 16th of 2026. That's when it was filed into the case. Let me see when the judge signed it.
Say that again. Say that again, please, so everybody can hear.
Yes, sir. So the dismissal of the misdemeanor deferred probation was filed in the misdemeanor case on March the 16th of 2026. His case expired on March the 9th. The only thing I can think of is the officers didn't send the paperwork through.
All right, so it expired on March 9th, 26.
And Judge, I'll print a copy of that
Thank you.
determination.
There it is. Probation expired March the 9th. The order dismissing it got signed March the 16th. Hold both them dates in your head for about 10 seconds.
6 days later, he's at the park shooting. The following day, his case was formally dismissed. I mean, the probation was still warm, the end of it, and it expired, but the order was not signed dismissing it until the day after he's shooting up Rogers Park. So that probation must not have been impactful. Didn't take you but a couple of days to continue your violent behavior. March 16th. By the county court of law judge. Sorry, Marvin, that doesn't help.
Understood.
That's terrible. Your relief,
The probation was still warm. Whew. 6 days after it expired is the date the state says this happened. And the paperwork closing it out wasn't even signed till the day after. Now understand what that is and what it ain't. That's a timeline. It's an allegation. Ain't no jury waited. But if you a judge deciding whether to open that door, that timeline is the loudest thing in the room.
requesting is flatly denied. He has shown from his history and his lack of appreciation of the seriousness of being held accountable in the first place, that violent behavior is something that he can't prevent himself from committing. So reducing his bond would only put us all in jeopardy and harm's way based upon his lack of appreciation of remediation of his conduct, in light of the fact that just days after he's finished his probation, he's doing a second set of violent shootings in Rogers Park. That this court finds reprehensible, and you will be held accountable in each of these two cases. The relief you're asking is denied based upon those reasons. I find him to be a threat to the well-being of the community based upon showing these.
Flatly denied. Reprehensible. A threat to the well-being of the community. That's a judge telling you exactly why on the record, with his reasons stacked up. And notice what the reason actually was. It wasn't the allegations by themselves. It was that 6 months of supervision came and went, and in his read didn't land. That's the whole ruling. So the bond stays where it is, and that young man waits, still presumed innocent, still got 2 cases nobody's tried yet. And I keep coming back to Mr. Perkins. He stood up there and told the truth every time it would have been easier not to. And the truth is what sank the ask. That's a hard way to find out the system's listening. If this hits you, subscribe. Uchi Court Reacts. We in here every week, and be safe out there for real.